So good morning, everybody. My name is Virginia Lombardo, and I'm an Italian lawyer, but I live in Brussels, and I work for an international company called CommScope in the telecommunication business. So data centers and, generally speaking, connectors. What I would like to do today, and you can see it also from the a little bit provocative title, is to start a sort of discussion. I hope this can be, as much as possible, a conversation more than just a speech, because what I tried to do here is try to provide and give you my personal experience as in-house counsel for different multinational company now located in Belgium, but working for all the EMEA market for my responsibility, and especially try to see from a practical perspective, how can we balance the needs. So for me, one of the key issue when I started thinking about this presentation was, okay, we would like to avoid conflict all the time. We know that, especially from an in-house perspective, every time there is a potential litigation, we need to face a reality. We need to talk with our CFO, the CEO, and start discussing what can happen next. And we would like to avoid that for a bunch of reasons. And when we are in that situation where it's unavoidable, we need to find the best strategy and decide how to proceed. But before, how do we avoid out? Is there a formula? Is there a possibility of really saying, okay, now I've done this, this, and that, and I'm sure in this case nothing can go wrong. I have avoided all the possible litigation. Is there a real formula? Is there a mathematical approach that we can use? I'm afraid no, also because in our business, there is no such a thing as 1 + 1 = 2. So we're a lawyer, and I think that's also the beauty of being lawyers, that we work with interpretation of things. So it's the beauty and also the difficult part, because 1 + 1 doesn't make 2, actually. So we need to understand how come in certain situations we have followed the book and something went wrong. And in other situation, actually, that probably was even riskier, everything went well, and we didn't end up, thank God, in the litigation. So that was my first question, and that's exactly where I would like to guide you through from, again, my experience, and I'm very happy to listen your experience and to have I know the short time, but having a quick conversation if that would be possible. So the first idea would be, okay, if we can have a very long contract, depending on the case, 20, 30, 40, 50 page of contract, and we can think about everything that can happen, maybe we can avoid litigation. That's a possibility. Try to put everything in a contract and try to think what could happen realistically. Now, the issue that we are facing is that we're in real life. And unfortunately, with the pace of the business, we have not one agreement to discuss, and then we stop, and then we start talking about the second agreement, and then we stop and we start talking about the third agreement. But we have multiple discussions at the same time, in many cases where we are involved. And again, I'm talking more from an internal counsel perspective, because that's my job, but I think something can be similar also for those of you who are in private practice. But so from one perspective, how can we secure that we avoid litigation? Well, we can think about everything that could happen. Possibility one, true, 50-page contracts for everything. From, let's say, buying or selling a small piece, depending on the industry we are, a small piece or a small part, to the biggest contract we can think of. Is this a real approach? Is this a concrete possible approach? Unfortunately, I'm afraid no, because all the time that I have started a discussion with the business and tried to say, okay, maybe, this 3, 4, 5-page contract is not covering everything that's happening, and maybe we need more time to start discussing and negotiating, and maybe we need to have another review call or another meeting. Of course, the business was like, yeah, okay, sure, we need to close this by tomorrow. And it's like, okay, wait a second. I know you have your needs, but I'm trying to support you. I'm your business partner in the company from the legal perspective, so let's try to find a way. And that's where I started discussing and understanding, where can we find the balance? I mean, is it right to ask me always the 1-page contract, perfect for every situation with no change that he can just end out and have it signed in 3 seconds? And am I wrong in trying to propose something that it's more organic, it's more complete? Where is the balance between his request of 1 page, 1 hour max negotiation, signature of the contract, and my ideal word of the 40 pages, different round of discussion and negotiation? And to answer that question, in my view, there is no a perfect, first of all, there's no perfect scenario, but it's not even a perfect moment to draw the line. Where do I start putting boundaries where, and I say, listen, not minimum than 20 pages and 14 clause, or not maximum than that. These are things that, in my view, don't really make sense from a practical perspective, because they don't match with reality. If we keep the same approach for every contract, if we keep the same approach with every situation, we will end up having issues, either internally or externally, or maybe both. So in my view, from an internal perspective, again, I'm discussing more from an in-house counsel perspective, the key thing to understand when we are discussing with the business is, what are we talking about? What contract is this for? Are we selling, again, if we're thinking about the selling contract, are we selling a piece, a product? Are we selling 10,000 pieces? Are we selling a system? Depending on our business, that could be the case. And which is the impact? Because a lot of time, I found myself, I have to say, doing the mistake of considering everything equally important. So the contract for one product, one single part, was equally important as the contract of 10,000 or the business of $10 million. And that's not the case. Now, we should give always to everything the correct degree of importance, I agree, but we can't, in a real world, consider everything equally important and make the same judgment call. Because this will be very good if we have all the time of the world, if we have no business pressure, but in a reality, in a real company, this is not going to happen. And what will end up, in my view, if we don't have at least some idea, some factors in our mind to consider, we can end up doing actually the reverse, panicking when we have a situation that could actually lead to a less risky situation, or lowering the consideration that we give to a very potential high risk situation. So in my view, the first thing is actually going back. It's going back to the business relationship. We need to have a good relationship with the business. And why is that important in contract negotiation? Because we need to be involved sooner than later. And that's one of the things, I don't know about your experience, I'm happy to hear what you guys have to say, but in my experience, at least 95% of the time, I was always involved last minute. No, I know, sorry, it's really, normally we would have called you in advance, but you know what happened? This huge urgency, we didn't know anything about it until last night, but it's okay, you have time, until today, 5 p.m. Is that okay? No, really, that's not the early involvement I was talking about. So one of the things that personally I tried to build from the beginning was the clear understanding of the fact we are a partnership. Lawyer, especially again, internal lawyer, but this is worked also with external counsel. We're a partnership. So if one of the two doesn't inform the other, there's something goes wrong. So the business should let us know right away. And the business should also try to give us as much information, because what sometimes I've noticed is that if we forget that we work, again, for us working in-house, we work for a company and we're not in our ivory tower where, I'm a lawyer, I don't understand what you're talking about, I'm sorry. So, I get to tell you what's the risk here, but don't go too much into detail, the technical part, for example, or whatever part is indicated, because don't forget, I'm the lawyer. If we keep this approach, it's not going to work. And therefore, where is the benefit if we have a good relationship and if we are involved early? We can make the judgment call, at least the first judgment call, about the risk of the situation and the level of, let's say, take and give of the scenario right away. If I know that the business told me, you know what, this is a contract for actually it's not only partial value, so it's not just a business tell me it's a $2,000 sales. It's not just that, but it's also What are we doing? It's just a sale, is activity service. Again, it's very difficult to make example that makes sense for everybody because it also depends a lot on the business you're involved. For example, in the business I'm involved right now, part of it, it's product, but a big part is service. And sometimes when the business tell me, don't worry, because we're talking about $4,000 or $5,000 worth value of service, so really minimum risk. Well, what for them is minimum risk from a pure economical perspective, for me can be very high risk from other perspective. Because if we have service, it means people, it means that something can go wrong and I need to pay attention to local regulation, hours worked, and a lot of other things that I would not consider. For example, in a pure sales of product that, let's say, we decide $10,000 of this, I ship it there, what can go wrong? Either the shipment and I cover that, or the product doesn't function. What's my max liability? Should I change it? Should I replace it? But that's one thing. So in my view, early involvement and rapid analysis of the business needs are really needed to be together in a very fast way. How do we develop that? In my view, really the key is good relationship with the business, and from our perspective, making the effort to go one step further and understanding the business really. Because what I have learned in my life, especially when I used to work before in a multinational that was doing motors, generators, and drives, very complicated business for me sometimes to understand. So I used to go in the factory physically and try to learn a little bit. Not because I was going to become an engineer, never happened. I'm terrible with all that stuff. But because I learned from my experience that if I didn't do that, I would have done very poor suggestion during contract negotiation, because what for me was absolutely important from a legal perspective was maybe never going to happen because technically it was not possible, or vice versa. I was underestimating something because I didn't understand what was happening there. So in my view, it's really key. The first two parts are key. And the first two parts will lead to all the rest, in my view. Because once we have understood what are we talking about, the risk, which is the risk, and again, the risk from a business perspective is not always matching our risk. The business sometimes tend to tell us, don't worry, economically the value is X. Therefore, maximum risk is that. Not really. That's not always true. And therefore, there is where we need to jump and say, wait a second, a couple of more questions to understand better. And therefore, I can tell you which are the crucial provisions of the agreement that, in my view, not only can be there, but needs to be there. They need to be there. Because, again, if we think that everything is crucial, I'm afraid that we're gonna have an issue with reality. Now, we need to understand that certain provisions are definitely always important. Alessia said a great thing before, in my view, about venue and law. I remember I was in a seminar once and somebody says, I don't understand why we underestimate so much this clause. This should be the first clause and we always leave it at the bottom of a contract. And a lot of time we're so tired after long negotiation that we don't even spend time and effort to fight for that. And that's true. My view should be not always there and always negotiated, but always in a thoughtful and meaningful way, because sometimes we end up with the repetitive course of mind, like, okay, Switzerland is a good country because they're neutral, so will be accepted by the counterpart. Something like that, very stereotype type of situation, but I've seen it in many negotiations, and that doesn't really make sense. But it happened. It happened in both ways, I've seen. And I've seen it a lot. Again, I don't know about you guys, but I've seen it a lot when the negotiation was very painful and there was like a droning type of situation. It was like, okay, now we're missing just one point, law and jurisdiction. And what do we do? Swiss law? Yeah, Swiss law. Swiss law is perfect, fine. Okay. Nobody checked if Swiss law in that scenario was actually good for the buyer, good for the seller, if there was any type of clause that would have no meaning according to Swiss law. But that was the idea. And I have to say, I found myself doing that mistake early back in the time. And I have to say that, in my view, that's a very important provision that we should always take into consideration. But why we should also thinking about that before we think about all the rest is because if anything goes wrong, at least we need to know where we're going to discuss and with which rule we're going to be applied. So in my view, what I think sometimes the business doesn't get is the importance of that provision, that in my view is definitely a crucial provision for the agreement, generally speaking, no matter which is the agreement. What sometimes the business doesn't get is if we don't even know where we're going to have the litigation in case there would be no other solution, we're going to fight to understand where to fight. What's the point in doing that? I mean, honestly, we said we don't want to arrive at litigation. Yeah, true, we don't. In some cases, unfortunately, we will have to. We try to limit to the minimum that, but there are cases where we start the action or vice versa. When they start, what do? We say, no, don't do it. If we already stop and pass that moment and they already started the litigation, it's not that we can say, no, please, sorry, can you go back and just not do that? We need to go. And if we start a discussion about where to fight, where to discuss, where to litigate, and which rule should apply, we're already lost in my view. It happened to me once. We spent 2 years in doing that. It was crazy. It was, in my view, crazy. We spent so much money on something that should have been avoided in first place. So again, going back to the points that in my view, the factors that in my view are key to be considered, after you've done the analysis and you have understood which are the crucial provisions, and again, venue and applicable law in my view are always crucial provision. But I can say they're not all crucial provision. I cannot tell you that for every agreement, all the crucial provisions are the same. I can tell you that venue and jurisdiction are always crucial, but I would not say the same for every type of provision. I would love to see, again, always this great 50-page contract where we cover everything and we thought about everything, but it's not feasible in life. So once we have understood that part, in my view, it needs to be very clear which are the non-negotiable points. And in some cases, we pick battles that honestly don't make sense. I can tell you, again, from my personal experience, I realized that I picked battles that were more my battles as a lawyer than a business battle. Because it came all to the first and second point. If you don't really know which are the risks, if you don't really know from a business perspective what you should fight for, you may end up picking battles that are not really the ones that you should fight always, because they're not always the same. They're not always the same. It's not that, again, just to make the example of before, if I'm selling just products or if instead I'm selling a system with also some services included, I cannot think that the battles I want to pick are going to be always the same, because the risks are different, the scenarios are different, and the situations are different. So, and from a pride perspective, I have to say, I'm pretty proud. So I know sometimes it's difficult to do exactly that, starting analyzing which are the non-negotiable points, but that means also backwards going, discussing which are internally the negotiable points and making sure we let it go sometime. That's something that is not easy. I don't know if you guys have the same experience, but for me sometimes it was painful. And sometimes, why was it painful? Because I was afraid from the business? Yes, definitely that was one case, but sometimes it was also from a lawyer perspective. It was painful because I wanted to have the clause because I knew that was drafted correctly. And the issue was that maybe that clause was not actually helping so much the final, drafting of the contract for what we said before. So just to finalize and try to proceed to the end, in my view, once we have done all the previous analysis, we need to make sure that we summarize the risk. Again, depending on the case, this could be a quick, let's say, meeting one-to-one with the business, or it can be in a long discussion, again, depending on which are the factors, which is the reply to the factors 1 and 2, we can have different scenarios. But making sure that the business understand the risk is as important as much as is for us to making sure we have understood the business case. Otherwise, the two things will not be aligned. And finally, we need to make a decision. And what is the decision? If we go back to the first question, the decision is, where do I draw the line on my need? The big, wonderful contract with 55 provision and everything immaculate and perfect, and we've thought about every single thing that happened in case we're able to do that, or the 3 pages contract with the 10 provisions that I'm pretty sure after a good assessment will be the one that will be necessary and important for my deal, the actual deal. So that's my view, and the final consideration in my view is that there's not a single, let's say, good answer to where to draw the line, but it really depends on what we said before. So I'm sorry I talked so much and I didn't give you the possibility that I was hoping to give you, but I'm happy to answer any question you may have now or after, or even during these 2 days we're going to be here. And in the meantime, I really thank you for your patience with me and my talk. Thank you.